Hello, everybody. Thank you all for joining us here today. Today we are going to be discussing the Washington State Supreme Court July 9, 2026 decision in the Bolina versus AssureCare. I want to highlight that this is a major decision for adult family home providers, especially providers who are employing live-in caregivers in their home. So I want to begin with two very important messages. First, this ruling is significant. The Supreme Court held that the live-in worker exemption cannot be used to deny Washington Minimum Wage Act protection to live-in caregivers working in adult family homes. Second, the case is not finished. The court decided the constitutional issue part of it, whether or not the live-in exemption is constitutional or not constitutional, but it did not decide on a couple of other things, including the retroactive payment and the prospective payment piece, which I'll highlight later on today. I want to make sure that as I'm going through these PowerPoint slides, you are all kind of thinking about your own situations and your own caregivers, and if this applies to you or how it may be applying to you. So why don't we start with the history of the case, and then we can go from there. So a little background / timeline. This issue, so back in 2024, so from 2024 to 2021, there were caregivers that have worked at AssureCare Adult Family Home. A couple of caregivers worked at AssureCare Adult Family Home. In 2023, the AssureCare caregivers sued the Adult Family Home, basically alleging Minimum Wage Act violations and constitutional claims. In their lawsuit, they included things like failure to pay minimum wage for all hours worked, failure to pay overtime, failure to provide meal breaks, rest breaks, or sick leave. And then they requested a declaratory judgment that live-in exemption violated the Washington Constitution. I want to highlight a couple of things here. And one of those things is the fact that when I really encourage everybody to go read the decision that was that is currently available online. There was a couple of things on there, and I'll talk a little bit more about it. But one of the things is the fact that AssureCare just did not have enough documentation, especially around the rest breaks, the meal breaks, and those kind of things. And so you'll hear me as I'm talking through this whole thing about how important documentation is, and to please make sure that you're documenting everything in terms of your staffing, your business, your payroll, all that stuff. So June through August of 2024, this is when the attorneys argued the case in Superior Court. September of 2024, this is when the Superior Court granted a partial summary judgment. And so it's partial because they decided on some of the things, but they didn't decide on all of the things. And so again, they decided a partial summary judgment on the constitutional issue. They did not decide on the remedy, payment, timing, and remaining claims that were left with the case. And then July 9th is when the Washington State Supreme Court affirmed this decision and basically sent back the remaining pieces back to Superior Court. I want to kind of highlight a couple of things here. I will say that I was particularly aware of this Supreme Court issue. I worked at the Adult Family Home Council between 2022 until the end of 2024. At that time, right before I left, I remember being aware of the situation and then thinking, oh no, this is going to impact a lot of adult family homes. But then I left the council. I went to work at a lobbying firm for a period of time. I didn't come back to the council, or at least not to the council. I didn't start working again with the council until around May of 2025. That was after the 2025 legislative session. And at that time, my capacity was more on lobbying legislative issues. So not necessarily engaged in this particular situation, but I was just lobbying on more regulations, policies that may have gone through the legislative session. So again, May is when I started more of my lobbying work with the AFH Council, and then I didn't start with the council. I didn't become interim executive director with the council until March of 2026. And that is when, as soon as I came into this position, not long after an adult family home provider reached out to me, letting me know that this issue was still ongoing and if I was aware of it. I was surprised to find out that it was still ongoing. I, for whatever reason, had assumed that it was resolved. But nevertheless, I reached out to board members immediately, notifying them of the situation and then letting them know what next steps that they wanted to proceed forward with. Immediately, the response back that I got from board members were, we need to reach out to attorneys and figure out, what we can do in this situation. Let's file an amicus brief and let's file the proper protocol to try to address this because this is going to have a major impact on adult family homes. So we reached out to our attorney who's been working with us for a very long time, and he did quite a bit of research, came back to me after a little bit later and said, unfortunately, we had missed the deadline to file an amicus brief or really do anything with this case. That if we needed to do any of those things, I believe the deadline he had mentioned was back in October or August of 2025. I can't remember the exact month that he mentioned, but again, around that time frame, October or August of 2025. And then my following questions after that was, well, was there anything else that the council could do in terms of doing anything at all? And his response was, no, there's nothing else at this moment in time. All we can do is wait for the decision and then see and then go from there, basically. And so that is what the council essentially decided on doing. We waited for the decision to see what could possibly, which way the court was going to be leaning on. And so I wanted to provide that perspective as far as a timeline here of events that have happened at the council, so you all understand that this is not something that I personally have chosen not to take on or work on, or the board has done the same. It's the timeline as far as when it was time for us to submit things like an amicus brief or additional documentation. We just did not meet the deadline for that. So again, we get to the Washington State Supreme Court. July 9th brings out their decision. During this time, prior to this time, a SureCare attorney argued that the minimum wage and overtime obligations could destabilize the adult family home industry. And while the court acknowledged the argument, they still felt that the financial consequences were not reasonable ground to deny required worker safeguards. And so they did cite, that the home, that there was a violation of Article I, Section 12, that the RCW 49460103J violates Article I, Section 12, as applied to live-in caregivers at adult family homes. And so right after that, it was not long after that, we started digesting the material to try to make sure that we are informing adult family home providers. Unfortunately, for my situation, 2 days later, I had to deliver. I gave birth, and so we just could not get that information out in time for you all as far as updates. So the court decision really quickly. So the court struck down the live-in exemption. Again, the Washington Supreme Court said that the state could not keep using the live-in worker exemption to deny minimum wage and overtime protections to live-in caregivers working in adult family homes. And the court viewed adult family home live-in caregiving as demanding and health-affecting work, and said administrative convenience was not a good enough reason to take away wage protections. And so that is why they decided that this live-in exemption in AFH no longer applies. After the court had decided that, they then sent the case back to the Superior Court. And I'm going to talk about it right here. Like I said, so what is left, right? One of the reasons why they sent it back to Superior Court is that Superior Court needs to make a decision on retroactive payment or prospective payment. So really quickly, just back up. moving forward, there's no longer a live-in exempt, like adult family home providers are required to pay their caregivers the minimum wage for all hours worked. That you can no longer provide a daily rate that's less than the minimum wage. It's a big clarification that I want to make here. While you could still have live-in caregivers at your facility, at your home, you need to make sure that you are, if it's $17 an hour for as the minimum wage in your area, your region, that you are paying that minimum wage and that you're not paying less than that. Is the big clarification point here. I know that some homes have a daily rate of, whatever that may be, and it's less than the minimum wage. That is no longer acceptable with this decision. The retroactive payment piece now. When the court sent this case back to trial court or superior court, the big question here is whether or not back pay needs to be applied for every caregiver who received less than the minimum wage. And so then the two sides are going to be arguing the case. The judge is then going to have to decide, should all adult family homes across Washington state have to pay back pay for any caregiver that they paid less than the minimum wage as far back as 3 years. This could be extremely devastating for our adult family home community, partly because of the fact that the reimbursement rates that adult family home providers are receiving are not even sufficient enough to be able to pay caregivers adequate wages, first and foremost. But secondly, it would also be devastating for these homes and could essentially force them to close because again, where's the money coming from, right? Where would they get these funds with these low Medicaid reimbursement rates? With that said, the council is going to be doing a couple of different things here in this piece. We're going to be arguing that the adult family home industry would not be able to sustain this, that the reimbursement rates were not sufficient to be able to provide these hourly wages that is being requested. And then we're going to be filing an amicus brief, kind of talking about what the impact looks like. At the same time, we're going to be asking providers for impact statements of what this would mean for their home if they're put in this place. We will be arguing more for the other coin of this is a prospective payment piece, payments to be applied prospectively. And so, and the prospective payment piece is that is basically saying moving forward, any home that does not do this, this will happen. And this is what we want to argue is that this rule should not be backdated. It should be, if we're going to be applying it, we should be applying it moving forward, like looking forward. If any homes violated this, then we're doing X, Y, and Z. Really quickly, we have a survey out where we're collecting data to try to gather on the retroactive payment piece and the impact of that, what that would look like in adult family homes. We'll be collecting impact statements. We will be filing an amicus brief. And so we would encourage you all to fill out that survey. And then as we roll out sort of those impact statements, if you are if you're open to speaking about your home in particular, we encourage that as well. So the retroactive payment question is definitely in the air. So what this means, as I highlighted this quickly, in the last couple of slides, but what this means for adult family homes, again, live-in caregivers in adult family homes must now be paid at least the minimum wage for all hours worked. Those workers must also receive overtime for hours over 40 in a work week. Providers do not have to end live-in arrangements, but they do have to change how those hours are paid. And so I also want to clarify that this also applies to people who are in your home that are working a 24-hour shift. If they are going to be sleeping if they are sleeping in your home, then you need to make sure that you are paying them, all of your caregivers, at least minimum wage and plus overtime. I highlighted on what the council was doing a little earlier, but just to reiterate some of this stuff, we're gathering data, how many adult family homes have been impacted by this ruling, and that data is being collected through our survey that is currently out already. We will be doing, we will be preparing an amicus brief We'll be highlighting how retroactive payment will be devastating for adult family homes. We'll be collecting impact statements. And obviously we are currently in CBA negotiations. So we're obviously going to be sizing this new rule change and why adult family home providers need an increase in their daily rates. And then we'll continue to have conversations with legislators, governor's office, media, and so on and so forth. A couple of things. So kind of wrapping up that whole Supreme Court issue. One thing that I want to clarify here for you all is engaged to wait versus waiting to engage as it applies to the Supreme Court ruling and what it looks like moving forward, right? So engaged to wait it means that these are the hours that you have to pay your caregiver. So if a caregiver must remain on site and be available to respond during residents' naps or nighttime hours, they are generally considered to be engaged to wait, and that time is hours worked, even if they read, watch TV, or use the phone while waiting. And then waiting to be engaged, those are hours that you don't have to pay for. If a caregiver is completely relieved of duty and free to leave the premises, run errands, or pursue personal activities, that off-duty time is usually not hours worked. And so for some examples, if a live-in caregiver is allowed to sleep overnight, but must stay on the premises to be available for emergency evacuation or other resident needs, those hours are very likely hours worked because the caregiver is not free to leave and remains under the employer's control, especially if there's not another staff person to attend some of these emergencies. So if you have one live-in caregiver and you have 6 residents, and you have 6 residents in your home, and that living caregiver is sleeping in the home, is sleeping in the resident, the home, your home, you should be paying that caregiver for the full 24 hours because technically if an emergency happens, if anything were to happen, that live-in caregiver would need to essentially, their sleep could be interrupted. It's no longer uninterrupted sleep. And so the only time that you would basically be able to not pay a caregiver for sleep time would be if you were to give them 5 hours of consecutive uninterrupted sleep, but you could deduct up to 8 hours max. If they were to get 8 hours of consecutive uninterrupted sleep, then you can deduct that. Another example, if a caregiver is required to remain at the adult family home overnight, even with rare interruptions, the fact that they cannot leave the worksite and must respond if something happens typically makes that time, paid time. If a caregiver cannot leave the property without arranging a qualified caregiver to replace them, that restriction strongly suggests they're engaged to wait and entitled to wages for the entire time they are required to remain available. When a caregiver spends the night sleeping but is expected to respond if a resident falls, wanders, has a medical emergency, or otherwise needs assistance, those hours would generally be treated as hours worked, even if no calls actually occur. And then I'll go over a couple more examples here. If a caregiver wants to leave but cannot do so until another caregiver arrives to relieve them, they're typically considered to be working until they are relieved because they remain responsible for residents and under the employer's control. When licensing rules require sufficient staff on site at all times to respond to emergencies and the caregiver fulfills that requirement by remaining overnight, the logic here, the court's logic, supports treating those hours as worked hour time rather than unpaid, treating those hours as paid time rather than unpaid sleep time. And if a caregiver may watch television, read, or sleep during the quiet hours, but cannot ignore resident needs or leave the premises, that time you would generally consider that as, paid time or engaged to wait rather than off-duty personal time. What I want to highlight here before I wrap up is the fact that the federal law, as I highlighted a little earlier, does not have a live-in exemption. What federal law says is that you are required to pay your caregiver at least $7.65 an hour, I believe. But as the provider, you can deduct things like you can get things like sleep credit. You can, as I mentioned earlier, you can get if your caregiver is sleeping 5 hours of uninterrupted sleep, you can deduct that, and you can deduct up to 8 hours. Washington State does not have things like sleep credit because they had the live-in exemption for adult family homes. And now that the live-in exemption has been lifted, we have been working with LNI to figure out what this looks like, whether or not sleep credit is going to be applied, and if so, what this looks like, what kind of additional rules are going to be coming with that. What I do want to highlight is that at the very minimum, I encourage adult family home providers to at least, I know it's really uncertain right now, to at least make sure that you are following the federal law and make sure that you're documenting. As I mentioned earlier, one of the biggest things, if you go through the decision and you kind of read it, one of the things that was mentioned in there was the fact that the AFH that was sued in this situation was asked to produce certain documents such as around rest and meal breaks and sleep time, and they were just not able to produce those documents, or there was not a sufficient enough case to say that, oh yes, these caregivers were getting what they needed at the AFH. So if you haven't been documenting, I encourage you to start documenting from now on. If you need to, go back and make sure that you've documented properly in the past, please make sure that you documented properly, so that something like this does not happen to you. But as we continue, as everybody starts digesting this information, we continue to work with LNI. We will produce educational material. For you specifically, we encourage you to please fill out the survey so we can figure out what the impact looks like across adult family homes. Please make sure that you subscribe to the Adult Family Home Council newsletter so that when we are reaching out on impact statements, if you are open to providing that kind of information, we'd love for you to be able to do that. And then we are obviously, like I said earlier, in CBA negotiations to be advocating for higher rates. And then we'll continue to talk with legislators and state agencies and the governor's office to chart what a path forward looks like. So with that, thank you, everybody. Yes, I highlighted this a little earlier, but the Supreme Court essentially decided that the live-in exemption in adult family homes is unconstitutional. What remains unresolved is the retroactive and prospective payment piece. The big question is whether or not adult family home providers across Washington state are going to have to pay back pay as far back as 3 years for any caregivers that they may have not appropriately paid the minimum wage to, or not. So that's the big question that we're going to be continuing to work on. And yes, and the ruling for providers today means that if you are an adult family home provider who has live-in staff, whether that's 24-hour shifts, 24-hour shifts count as well. If you have live-in staff, you need to make sure that you are paying them at least minimum wage. You can no longer just pay them a daily rate that does not equate to the minimum wage when it's divided out. It needs to be the minimum wage. Yes, so federal law says that if the live-in caregiver needs to get 5 hours of uninterrupted sleep for you to deduct that from their pay. If their sleep is interrupted, you do have to pay that out. You can deduct up to 8 hours of uninterrupted sleep. So if you, as I gave an example a little earlier, but if you have one caregiver and 6 residents, and you're expecting this caregiver to wake up during emergencies or tend to staff resident needs while they're sleeping, you generally have to pay that caregiver the full 24 hours. So again, for Washington State, because this live-in exemption was lifted, we are still working with LNI to figure out what that looks like. But at the very minimum, I would encourage you to make sure that you're following federal law, because it won't be lower than the federal law requirements. Yes, the more immediate steps that I would encourage you all to take is document everything. Make sure that if you haven't been documenting properly in the past, please make sure you're documenting. If you stopped documenting for whatever reason, please start documenting. Make sure that you're indicating when your caregivers are taking breaks. So when they're taking their meal breaks, when they're taking their sleep time, and when they're taking their lunch breaks. And then make sure that you have your home is properly staffed. So if you do have a caregiver in your home that's watching 6 residents, and you want to say that, okay, now this caregiver is asleep, there should be somebody else there that's attending to these residents if an emergency happens. There should be somebody else there where if something happens, emergency happens, anything at all, that they are the ones that are expected to attend to these individuals and not the person that's sleeping. Yeah, well, I can't speak to the type of records that the providers should be, should be keeping, partly because we're also waiting for guidance from LNI. What I can say is have a timesheet of everything, the breaks, the rest breaks, the meal breaks, the lunch breaks, the sleep breaks, like all of it. Have a timesheet of everything for every one of your caregivers and just make sure that you're keeping that in a binder somewhere. Yes, providers could potentially face retroactive liability. That is, so right now it is not currently decided on. The case went back to Superior Court. We are waiting for a trial date. The council will be filing an amicus brief. We will be collecting impact statements from adult family home providers to show what the impact this is going to have on AFHs. We will be presenting data to really fight against this retroactive payment piece so that the courts are looking more forward rather than backwards. If the courts were to look backwards, it could be as far back as 3 years. So you could potentially have caregivers who worked in your home 2 years ago saying that, oh, you may have not paid me appropriate wages and you need to pay me appropriate wages. We are still waiting on LNI to provide appropriate guidance. I would follow what the federal law says as far as those kind of credits, because again, whatever the state comes up with is not going to be lower than the federal law. So as far as credits, again, as soon as we know more about this guidance from LNI, we'll provide that. Can live-in caregivers be independent contractors? I am going to hold off on answering that, probably because I feel like that's more of a legal question and it's a little bit more nuanced. And so your live-in caregiver should be a staff in your home. As I'm not aware of independent contractor situation, but again, I'm going to hold off on answering on that just because I'm not an attorney and it's a little bit more nuanced. There's no timeline right now just because everybody's kind of digesting the information. It only came out July 9th, so it's going to be a little bit of time before the information the information gets digested and we're able to produce training materials from LNI. What I will say, as far as conflicting guidance, I would encourage people to, at the very minimum, make sure you're following all proper protocols as far as federal law. Like I keep saying, that whatever the state comes up with, it's not going to be less than that. If you have questions about particular things that you've been hearing, I encourage you to reach out to the Adult Family Home Council. Maybe we can try to help see if we can get your question clarified. I will also encourage you to reach out to LNI too. They're very good about responding to providers. Exactly, and that is the argument that we're going to be making too with the state. I do agree with you that the low Medicaid reimbursement rates have not made it exactly easy for adult family home providers to hire staff at minimum wage. And so again, this is an argument that we're going to be making with the legislature. We're obviously going to be making at the Superior Court, and then we're going to be making during our arbitration CBA negotiations. Yes, and I've highlighted this a little bit earlier. Can AFHC participate when it returns to the Superior Court? Yes, we will be participating. What is AFHC doing? A couple of things. I don't know if you saw my slide. We're gathering data, so we put out a survey to help us gather the data on the retroactive payment piece to figure out what the impact looks like as far as live-in caregivers in adult family homes, and then what the impact is going to be on residents, especially if homes are having to close. So we are gathering the data, so please make sure that you're filling out that data. We are also, like I mentioned, we're going to be filing an amicus brief. We will also be collecting impact statements. We are in negotiation, so we're obviously going to be bringing up the Supreme Court issue and try to advocate for a better increase for adult family homes. But then we're also looking at exploring some legal paths as well that may not be ready to fully share or flesh out here in this conversation. Yes. So how can providers help? I encourage every single adult family home provider to please become a member of the council. The more resources that we have, the better chance that we have of being able to advocate for you, to hire more staff, and to make sure that we have what we need to advocate for you as the adult family home provider, so that your business can succeed. As far as the survey piece, we do ask for your first name and your last name, and we ask for your license number in the survey, but that information is going to be staying with the Adult Family Home Council. That information will not be provided to the legislature, to arbitrators, or the state agencies, or anything like that. The only reason why we're asking for that information is to remove things like duplications. So if somebody with the same license number fills out the survey, we can say, oh, this is a duplication. We're taking this out to ensure that our data is accurate, that we're gathering this, we're costing out the correct numbers. And so, yes, the survey is confidential. Your information is not going to be given to anybody unless we consult with you personally. We reach out to you, but it's not exactly anonymous, probably because we need to be able to remove the duplications and make sure that it is accurate in the first place. Yes, so one of the things that we've rolled out is our Adult Family Home Council SMS, where you can opt into text messages. And once we identify some of these big issues that are going to be impacting adult family home providers, we will be sending you a text message letting you know that this is happening. We're going to have a webinar, host a webinar, and please attend. So the SMS piece is a big one. The second piece of this that we're doing is we are doing a member-only Facebook group where we will be sharing information more frequently to adult family home providers. We wanted to make sure that it's member only so that providers feel comfortable to share what they want to share. We are also a couple of other things. I'm consistently looking at what's being what's out there, what's online, so that if anything is affecting adult family home providers, we are notifying you right away. We also provide a newsletter to ensure that we're communicating this information out to adult family home providers. So you can also subscribe to that, and we have our social media pages. To answer the question, what is the council doing to ensure that we're identifying these things appropriately? We have staff on these issues that are kind of looking at these things, but then here, the things that I just listed out are all the different communication channels that we will be ensuring that you are notified appropriately with these things. Yes, we have a couple of places. We have our document library as one source of that. As far as training, you could always reach out to the Adult Family Home Council. We have our webinars or recordings that we could obviously email out to you, but will be available on our site somewhere as well. And then we have our social media, like I mentioned earlier, social media pages, our newsletter, and other places where you can get a lot of this information. Great. So thank you again, everybody, for joining us. And as I walked you through sort of the Supreme Court live-in ruling that just recently happened. I want to highlight the documentation piece. I want to highlight the survey piece. And please reach out to the AFH Council if you need any clarifying questions, if you have any clarifying questions or you need further assistance. So with that, thank you.